Let's go ahead and get started. So this is our webinar series, Navigating New Squatter Eviction Laws. Joining us here is Adam. And we'll jump into introductions here in a moment. But yes, thank you so much for everyone for joining. I also want to take a moment to say happy Juneteenth to everyone that is celebrating that today. So thank you for joining us on this day. And then I also want to take a moment to thank those of you joining from the Greater Cincinnati and Northern Kentucky Apartment Association, who we've partnered with. I know a lot of you are part of that association. We're so thankful for you guys to join and for your continued support as well. All right, so as I mentioned, we'll start with introductions, then we'll go into kind of an overview of what's changing with eviction laws and why. And then we'll kind of jump into some of the important things in regards to legal recommendations that you guys want to know, I'm so sure, as property managers, some of the questions surrounding that, as well as research with your specific state's eviction laws, because it varies so much from state to state. Recommendations on what evidence to gather, because that is super important, as you'll find out later, as Adam's going to talk about, and specifically what not to do. I think that's one of the more important things to be very aware of when you're addressing squatters and evictions. And then we'll kind of dive into how surveillance technology can help with this. I'll talk a little bit about what Cloudastructure does and what we offer. And then as I mentioned, we will do a quick Q&A at the very end. But again, please throw your questions into the chat. We'll address them as we go through. But I do want to start with some quick introductions. Adam Edgecom from Cobb Gonzalez has joined us today. He has been deemed the nation's eviction law expert. So we are very honored to have him on this call. We're excited to get some of his expertise and knowledge. So Adam, if you want to do a quick introduction to the team.
Yeah. Hey, good morning, everyone. My name is Adam Edgecom. I'm a partner with Cobb Gonzalez in Jacksonville, Florida. I've been practicing law about 16 years now. Our firm does general business litigation. We do have a strong focus on construction and real estate and condo and HOA law. All those kind of go hand in hand. And to be candid, I work with a lot of commercial property owners, but I also represent plenty of property managers of residential properties as well. So I've got experience, both with commercial situations and residential as well.
Again, thank you so much for joining us, Adam. We're very happy to have you here. And then a quick introduction to myself. My name is Jen Free. I am Director of Sales with Cloudastructure. I've been with Cloudastructure for about 3.5 years, but my background is really on the operations side. I worked as a leasing consultant, as a property manager, and up as a regional. So I'm very familiar with what you guys deal with on a day in, day out basis in terms of dealing with squatters, dealing with evictions. I have knocked on doors with the police to evict tenants, and I know how scary it can be. You don't know what's going to be on the other side of that door. So yes, this is very close to me. I am very familiar with what you guys deal with in this. So I love working with Cloudastructure. I'm super passionate about what we do because I've been on site, and I'll dive into what Cloudastructure does here in a moment. But that being said, Adam, I know you gave a quick introduction to yourself, but if you want to talk a little bit more about, I'm going to jump ahead to Cobb Gonzalez.
So we were founded in 2020. I came over here in 2023. Several of my partners, we all used to work together at another firm and found our way over here. I myself, lifelong Jacksonville resident, all very involved in the community. Many of my partners are board certified in different areas, construction, association law, trial law, things like that. And we're just kind of a typical mid-size for Jacksonville, mid-sized business litigation firm. We also have just opened last year an office in Orlando. We've got about 5 attorneys over there. And we've got attorneys licensed in Florida and Georgia. We practice all around the state in Florida, not as much in Georgia, but we do some Georgia work. And that's kind of us.
So going back to Cloudastructure real quick. So we really specialize in AI surveillance and also remote guarding solutions, which I'll dive into just a little bit more further down into this webinar. But we really specialize we do security audits of properties to really understand where we need to add coverage. and we understand that every property is so different. So in terms of offering security in an elevated stance, we offer that customized option. It's not just a one size fits all, but coverage in certain areas, and then adding that speaker for that really proactive approach to security, which I love so much. Again, that's why I'm so passionate about this, because I'm familiar with what you guys deal with in terms of security, lease violations, and specifically the topic that we're talking about today in regards to eviction and squatters. So we'll talk a little bit more about how surveillance and having that coverage and even the proactive piece of it can help with this specific topic. All right, so let's go ahead and dive into the meat of it. So a really quick history of squatters and squatting and what it's kind of looked like in the past, and then we'll kind of dive into how it's changing in the future. So in the past, although trespassing is a crime, a lot of states have been handling squatting as just a civil complaint between a landlord and a tenant because there's no evidence of a crime. So more often than not, law enforcement errs on the side of telling the property owners that they have to go through the eviction process, which is a long process. It's very costly. It can lead to, a lot of cost in terms of court fees, repairs, utility bills, lost income, vacancy cost. The list goes on and on. But more often than not, they've erred on the side of being better safe than sorry. And civil procedures can leave property owners unable to rent their properties for sometimes months, sometimes even years. So that vacancy cost is huge. And prior eviction processes really escalated risk because, as I mentioned, when you're knocking on the door, you don't know what's on the other side of that door. And so it's just a lot of unknowns. But on the right here, you can kind of see some statistics surrounding this. So I'm sure some of you may be aware of an incident that happened in New York back in 2024. It's a very sad story. This woman left her apartment to travel abroad for a few months. And when she came back, she found squatters in her apartment and they ended up murdering her, stealing her property, utilizing her credit card on a spending spree, but a very, very sad story. And so, as I mentioned, it's a scary thing that a lot of cities are dealing with. You can kind of see on these statistics, New York actually is Manhattan was the first city to pass laws surrounding eviction. So you can see that decline in New York, but also you can see the escalation. There's been a huge escalation in Georgia, but they're starting to implement some laws surrounding evictions as well. But more often than not, squatters are aggressive. And that's why we really want to talk about some processes that you can take to protect yourself, protect your tenants, and also understand that you're handling it appropriately. So that being said, Adam, I'm going to hand it over to you. If you can kind of talk about some of the differences between squatters and holdover tenants.
So the important thing to bear in mind, in the legal world, we kind of use the term colorable to mean credible or at least not frivolous. And so what the big difference between a squatter or a holdover tenant is, does this person have a colorable claim to legitimately inhabit the premises? And, the courts in situations, it's colorable, but it's not clear if it's totally legitimate or not. And so specifically, somebody who's going to have a colorable claim to reside or possess the premises is going to be a holdover tenant, a family member of the owner, a roommate or tenant who wasn't on the lease. Those folks, it's not immediately clear to the law that they don't have a valid right to be there. And so all of this is ultimately really concerned with the due process rights of the tenants. I know that can be very frustrating for the property managers and owners, but the law does need to give everyone due process. And so those folks, like I said, holdover tenants, family members of the tenant, of a legitimate tenant, somebody who may have rented it out as an Airbnb or a Verbo or something, those people have somewhat colorable claims to stay in the premises. Whereas as a squatter, all of the laws, and as the slide points out, they don't have a valid claim to the property. They don't have a valid lease that was signed by the actual owner. They're not an owner, a co-owner of the property. They're not a family of the co-owner. They aren't listed on the deed somehow. These folks just very clearly don't have colorable claims to the property. This is really, I know in Florida especially, has increased post-COVID. And so the law is just really for these obvious folks that we don't need to bring them into court and plug up our legal system. We can handle those folks, the squatters, a little bit differently. And all squatters are going to be trespassers. And the risk there is almost every state has some form of what is called adverse possession, where if someone just comes onto a property and possesses it, adverse, notorious, open, continuous, and hostile possession to the actual owner, after 7 years, that under the common law becomes your property, even though you didn't pay for it, you never were on the deed or anything like that. You just started occupying it and no one stopped you from doing it. So now after 7, 8, 9 years, it's now yours.
Wild. Yeah.
Yes.
I am curious, kind of taking it back to the history of squatting. Why has it been historically really difficult to remove squatters?
It's just that goes to the due process as well as, our court system. If you want to remove a squatter, that would be filing a complaint for eviction. Well, given what county you're in, just talking about Florida, if you're down in Miami, it might take you a couple weeks to get a hearing just to kind of get in front of the judge and get the case kicked off. Up here in Duval might be a couple days, couple weeks. And then on top of that, folks have kind of learned, we live in a much more kind of technologically complicated society than we used to. There's a lot of ways for a savvy squatter, trespasser to just slow the case down and gum up the works and ask for extensions. And then you can't get another court hearing for a couple of weeks or a month or something. And so it's just really easy to kind of manipulate the process. And the law treats these situations differently than, say, like a pure breach of contract, because the law does recognize if this person is an illegitimate tenant or inhabitant, that you as the owner are literally like losing money and being damaged every day. So recognizing that those damages and the way they accrue are kind of different in the rental or property ownership context than breach of contract or negligence or something, the law recognizes that we want to move these cases and resolve them as quickly as possible.
Yes, that is helpful. Okay, so now we're going to take it to the map. I know you guys are tuning in all across the country, and it, as Adam mentioned, it varies not even from state to state, but county to county. But in regards to states here, the states in green have passed new expedited squatter laws that both criminalize squatting and provide landlords with relief from the arduous and expensive court processes that they're facing. In regards to orange, the states in orange have pending legislation that can change. And then some states in blue are merely criminalizing, but they still require landlords to go through the lengthy processes. So Adam, could you talk a little bit about the difference between expediting and merely criminalizing?
So expediting, that's going to be a civil process where you as the property owner or the agent of the property owner is proactively seeking removal. The criminalization is going to be, you as property manager or owner, call the cops, hey, I got a trespasser. And what they'll do is come and arrest that person. If that person is trespassing and saying, hey, I have a legitimate lease, you shouldn't be removing me. You just have a criminal process. You might have had that person arrested for trespass. Maybe that's a misdemeanor. I don't even know if they do any real jail time, but they get out and they come back to your property or something. They still claiming they have this lease. The criminalization process wouldn't have dealt with that or addressed that. So the real big difference is just, one, you're in the criminal court system, and one, you're in the civil court system, and just the different remedies available.
Yeah, that is helpful to know. And in the chat, you'll see Lauren put a link to this map. It's an interactive map, so you can actually click on your own specific state to understand the bills and the laws. So go ahead and check that out. We'll go ahead and move on here. But yeah, check out that interactive map. Again, the link is in the chat. So now we're going to talk a little bit more about specifically holdover tenants. So Adam, if you want to talk about that a little bit.
Yeah. So, most folks here, if you're renting out property probably familiar with a holdover tenant, someone who lease expires and they just don't move out. Those are not going to be included in your expedited removal process like we had just talked about. Those folks are going to have a colorable claim to stay in the property. And the law does give you and presumably your lease probably give you remedies to address that. But again, sorry to repeat myself, it's just the court and the law recognizes, look, this holdover tenant maybe they shouldn't be staying there, but it's not so obvious that we can just expedite it and boot this person out.
So question, if someone illegally sublets an apartment when their lease specifically states that that's not allowed and the subletter doesn't go, can you use the expedited process?
So great question. So that person is going to have a colorable claim because even if, the original underlying lease has an anti-assignment clause, that subtenant may not know that. They honestly may be an innocent victim of the tenant who's doing fraud or someone else. So in a situation like that, that person is claiming some interest under some lease. So one of the issues here, like with dealing with Florida's law, all these laws are new. There's no case law. And literally y'all are seeing like my brain at work here. So like the Florida law says a squatter is someone who is not occupying it under a valid lease. So actually, and sorry to do this to y'all, but let me back up and correct myself. I think actually in that situation, if your underlying lease is very clear and unequivocal that you cannot assign it or sublet, and someone else is claiming under a sublease, I think you actually could do that through the expedited process because that's not a quote unquote valid lease. And the reason I'm sort of wishy-washy is, again, these are new laws. And as some of y'all may appreciate, a law or a statute may say one thing, but lawyers and judges might disagree over what those mean. And so until you start getting courts issuing opinions and some case law out there interpreting that statute, we don't necessarily know how the courts are going to enforce that. So in this situation, if it was my client, I'd argue that, yeah, this isn't a valid lease. We're entitled to the expedited process. But, someone else might take the opposite view and say, no, you had to treat this like a holdover tenant.
So, and to kind of lead away from that, in regards to verifying the squatter's status, there are so many different things that kind of go into that. Is that the landlord's responsibility, or should we rely on law enforcement to do that?
So that's going to be the landlord and or their agent, the property manager. That's their responsibility. And so just the way that the Florida law works, and I believe from the research I did, I believe Ohio, South Carolina, and Oklahoma, at least those states are similar to Florida. I think based on what I'm seeing, other states are probably similar. I'm just not certain. But the way the process is going to work for Ohio, Florida, South Carolina, Oklahoma is you as the property owner, you fill out a sworn affidavit saying, this person doesn't have a valid claim. They are not. The statute literally lists the things that you as the property owner have to put in your affidavit. They don't have a valid lease. They're not a family member. They're not a former tenant, all these things. And then you give that affidavit to the sheriff's office, your local police department. And just based on that affidavit, they are going to go and remove that tenant. What then happens is if you as the landlord have gotten that, like if you messed up and that person did have a colorable claim, or if you're just being a shady landlord who had someone removed, the law then gives that tenant rights against you as the landlord, where you're going to be paying treble damages, attorney's fees, and costs. So there's kind of some pretty decent leeway for the property owner in this situation. But if they use or manipulate the process, the consequences could be pretty severe monetarily. And I've got to believe that the first, again, because there's not a lot of case law out there yet, I got to imagine the first landlord who lies and has someone removed when they under the expedited process when they shouldn't have, I got to imagine the court's going to come down on them really hard to kind of set an example and show what's going to happen if you don't operate properly under the law as an owner.
Do you have, and I know you said the court's going to come down hard, but do you have any idea what kind of penalties those are?
So it's going to be whatever, damages that tenant had. If they lost their personal property as part of that, if they incurred costs to go find new housing, maybe they had to stay in a hotel temporarily. Those monetary damages are what, if I was representing a tenant, that's what I would ask for. And then you're also going to get your fees and your costs as well, which is a substantial portion of the damages. And then on top of whatever the money damages are, the statute, as I recall, I believe, has a treble damages provision, meaning, let's say you wrongfully evicted a tenant and he incurred $10,000 worth of damages. Now you're on the hook for $30,000 plus fees and costs. Plus, a savvy attorney might tag you for some punitive damages as well. And that could be any amount that the court sees fit. So these are good laws for when the facts merit them. But obviously, I'd never advise my client to manipulate or violate the law or lie in a situation like this. But there is some risk to the owner, and they just need to be certain about the person that they're moving against.
And there's a couple more questions in the chat, and then we'll go ahead and move on. This is kind of in line with what you were just talking about. But James asked, outside of the fines that you would pay to the wronged tenant, are there criminal penalties for lying on an affidavit?
I'm not aware of any criminal penalties, no. But as I'm sure everyone can appreciate, if you were getting hauled in front of a judge for violating this law and, an affidavit document that you are signing and swearing under oath is true, if it were to be proved to a judge that you lied on that to get a tenant out, like I said, probably not going to get much mercy from the judge, and they're probably going to try to make an example of you.
Okay, one more, and then we'll go ahead and move on. What criteria must be met to qualify for an expedited squatter eviction under the new law? Does it apply only to residential units, and what type of documentation or proof is required?
So it's only going to be for residential tenants. And I don't have the statute right in front of me, but essentially you just have to prove you're the owner. I went through this process for one of my clients earlier in the year. And what we did, we just had to prove, she owned the property through an LLC. So we pulled the deed, we pulled the records from the Secretary of State showing that, she was the manager of the LLC, gave those to the department here in the Jacksonville Sheriff's Office that deals with these. We gave them the deed, the business records to show she's an owner, and then gave them the affidavit, attesting that resident, wasn't a former tenant, wasn't a co-owner of the property, wasn't the owner's family member, all the things listed in the statute. So we just gave them that affidavit and that proof of ownership, and that was all that we needed. Yeah, really, truly, when they say expedited, they mean expedited. They're not trying to make you as the owner provide a ton of documentation.
Yep. Okay, that's great. We've got plenty of documentation we've got to provide elsewhere. So that is.
Yeah.
Okay, let's go ahead and talk a little bit about when you have a squatter, some of the do's and don'ts. I know this is super important to cover because, this could really make or break your case. So I'm going to touch on the do's. Obviously, confirm their status. Adam talked about confirming their status, some of the differences between that. So verifying whether it's a true squatter, a holdover tenant, a guest, or a subletter, because you would handle all of those a little bit differently. Next being documenting everything. That's going to be your friend when it gets to the court case. Photos, log all of your communications, any notices that you post, make sure that you have copies of those. And obviously pulling the camera footage, any coverage that you have of that specific person is going to help you in the long run. Contacting the local law enforcement. If the state does have an expedited squatter law, the police might be empowered to remove the squatter directly. But again, that varies state to state. And then obviously consulting an attorney. Obviously you want to handle this appropriately. And since there are so many things that go into this, you want to make sure that you're doing it the right way. So Adam, I'm going to hand it over to you to kind of talk about some of the don'ts.
The first one, as most folks are probably aware of, we kind of call that those things. And in addition to changing locks, shutting off utilities, removing property, we kind of refer to those as self-help. Don't engage in self-help. That's the quickest way to turn the law against you, even when you're totally in the right. So wait until you've had them properly removed before you go changing the locks and taking property out, things like that. I'm certainly guilty of number two. Sometimes problems, it's like, man, I just don't even want to deal with this. It's too much. I got too much on my plate already. I can't tell you how many billable hours I probably have in my career from folks who thought, oh man, I just hope it works out okay. And then it did. Unfortunately, in a situation like this, you got to be proactive because the longer you wait, those damages and just the difficulty in addressing it is going to increase. Hopefully this is somewhat obvious. Don't engage in confrontation. Like Jen was talking about, that unfortunately the woman in New York who was killed, folks are desperate. Folks aren't squatting because it's fun or easy. They're doing it because they're up against the wall. Doesn't make it right. I'm not siding with them, but just for the point of desperate folks do desperate things. And kind of the corollary to that is as well, I've worked with plenty of landlords and property owners who they're not heartless. They understand folks have challenges and they want to work with the tenant. But unfortunately, they let it go on too long. They want to hope that the tenant is going to pay and they're not going to have to evict them or take some other action. And 3, 4, 5 weeks, 2, 3, 4 months go by and it's back and forth via email. And then property manager looks up and goes, man, it's 4 months down the road and I haven't accomplished anything. And that happens all the time. I'm literally dealing with a commercial eviction right now that kind of happened in. And I told the client, I said, look, should have just contacted me right away. We could have addressed this. It would have been a lot easier. Feelings aren't as entrenched. So don't dilly-dally and try to make a good faith effort to resolve it. But one attempt or so, a couple weeks, that's at the most, and then move on. And then obviously, if you have co-owners or if you're a property manager, make sure you're in communication with the owner, empowered to make the decisions. And kind of piggybacking off of what I was just saying, talk with them, get a clear game plan and strategy in place and move forward with it without delay.
Great. Yeah, thank you for covering that. A couple of questions in the chat, and then we'll go ahead and move on. I think we touched on this previously, but Lauren asks, who verifies the status of the squatter, the property manager or the law enforcement? I think you mentioned
only so law enforcement, they don't want to open themselves up to liability either. So it's all on the landlord. They're only going to look at, okay, yep, you signed the affidavit. It's in the statute. You proved you're the owner. We're going to take you at your word. And if you're lying, then tenant's going to, have rights against you.
Perfect. Thank you. And Arissa asks, if someone passes away and they have someone in the home, the lease technically expires once the person passes away. But do we still file eviction on the deceased? And I believe this is in Virginia.
So this, again, just because these laws are new and there's no case law out there, I think you could argue it either way. You could argue that as the surviving family member, you could say, look, I was living here. She was the tenant. No one told me I couldn't live here. Landlord's known I've been here. And that person kind of has a colorable claim to the property. But again, as I was talking about earlier, if that lease clearly says, look, only the decedent, if only the decedent is the tenant and it's very clear, no guests, no other tenants, something like that, then if wanted to be an aggressive lawyer, I think you could argue that, look, that wasn't a valid lease. And that's what the law contemplates. And so I think you would probably evaluate that on a case-by-case basis. Has that tenant, before he or she passed away, and then their relative, have they been amicable and friendly? Are they trying, is the rent being paid on time? In that case, I don't know that you would go the expedited route, but if they're putting holes in the wall and telling you, go screw yourself, I'm going to be here for the next 3 years, nothing you can do about it. Maybe you want to get aggressive and do the expedited process. And so that really goes to one of the points you made, Jen, on the dues. Consult an attorney, tell them the facts. Each case is going to be unique and different. And that's certainly one that is not real crystal clear, black and white.
Yeah, good question, Arissa. Okay, so some things that you can do to deter squatters, like obviously deterring them in the first place is great, so you don't have to deal with them in the long run. But this kind of goes without saying, but securing the vacant units immediately, obviously making sure that the locks are changed, making sure that the windows are secured, putting yourself up with the best case to deter squatters from even entering the unit in the first place. And then conducting regular inspections, daily, weekly, having your maintenance supervisor, maintenance tech, someone on your team going routinely to each vacant unit to make sure that there is no one trespassing at that point. No trespassing signs, post them throughout the property. Give yourself the best case scenario to set yourself up against deterring squatters. And then partner with your local law enforcement. They're there to help you to understand the laws and the regulations for your state specifically, but make sure that they're on your side. be a good neighbor. Be the neighbor that you would want to have upkeeping the property. And ideally, they would help you out. If they notice any suspicious activity, they would notify you and vice versa. And then last being surveillance and monitoring. Set yourself up for success with having that additional coverage. That verified video is going to help you in that court case if it gets to that point. Adam, do you have anything to add to that?
Yeah, I was just going to throw in, just additionally to not so much deter the squatters, but to potentially deal with them successfully. Something really important is clear lease language, as I mentioned earlier, particularly as to assignments and subleasing, as to authorized guests, authorized residents, make it very clear who the actual tenant is. Most of my clients, they always get the actual tenants a copy of their ID, some kind of photo ID. Absolutely, that would be a good idea. You never know, that might come in handy trying to prove to a judge that someone didn't have a valid claim to the premises. And importantly, I assume most people are, if not everyone, is already doing this, but change the locks, not in a self-help, but once you have a new tenant, change all the locks so that former tenant doesn't access and come in and say, oh, I'm supposed to be here. And again, a lot of folks already do this, but consider owning the property through an LLC. It's just my opinion, but Florida statute contemplates you have to claim, you're trying to go through the expedited process. You have to confirm that tenant is not a family member of the owner. Well, if it's owned by an LLC, I would argue they don't have any family members. So even if you had you own a property through an LLC and, your crazy aunt is in the property, I would argue to a judge that, look, she's not a family member of the owner. That might be a little slimy lawyer position or argument, but I think it's valid. So a lot of folks own their properties through LLCs or corporations to avoid liability. That's just another area that I think might help.
Yeah, no, that's a great point. There are so many loopholes and everyone has a crazy aunt. So protect yourself for sure.
Yes.
Okay, so one of the things we kind of mentioned in regards to setting yourself up for success is coverage and surveillance. So just talking briefly about what Cloudastructure offers. Again, we specialize in AI surveillance, and technology can be your friend. Utilizing AI for those alerts that come through to really make a proactive approach to your security. So you're proactively deterring things as opposed to reacting to something that has already happened. So you can do things as awesome as setting up detection zones. You can set up motion alerts. You can set up directional alerts, and utilizing our remote guarding team is really what makes it that proactive approach. So we have live agents that can access and watch your live feed, and utilizing the technology and those AI, artificial intelligence alerts that are coming through, they're addressing this activity in real time. And so they're determining if it's suspicious activity. They're able to contact the authorities on your behalf because most of this might happen in the middle of the night when you are at home sleeping. And so really having those extra set of eyes on your property is really going to set you up for success. And then utilizing our remote guarding, every incident that happens comes with an incident report. So we talked a little bit earlier about documentation and how that's going to help you. So really having that extra that data, those documents to support your claim and to support your case is really going to be great. So we're also camera agnostic. So I just want to mention, if you already have cameras, our goal is to work with that existing infrastructure as much as we can. We're an end-to-end security company, so we can help you add cameras if needed. But right there, if you already have cameras, we can layer the technology on top of that and add the remote guarding piece. So we'd love to talk to you a little bit more about that if that's something that you think could be beneficial for your property if you're struggling with squatters. So a couple more questions and then we'll jump to the Q&A. So another one that popped up, Ohio, can a tenant evict a guest without the ownership involvement?
That's a great question. If they can, in my mind, the actual question is, could the tenant evict the guest? I'd probably need more facts about the situation. Try not to get into the legal weeds, but when you talk about standing, do you actually have rights to sue someone? If that tenant does have the right to evict the guest, I would assume you would not need the owner's involvement at all. That you're the possessor of the premises, you want someone out, no need to involve the owner.
Okay.
Hey,
All right.
real
And
quick,
oh, yep.
sorry, Jen, I wanted to jump in. I don't know what the original asker's scenario was for that question, but maybe I'm assuming Jen has a lease on an apartment, but she was in a long-term relationship or had a friend staying with her paying half the rent. So that friend is not technically on the lease, but they want them out. How would that situation go type thing?
Never run into that. And that's where I get into, I don't know if the owner would have to bring that action as the owner with an improper tenant, or if the tenant would have the right to remove that guest. That, I'd probably have to think that through for a little bit, look at the lease and Ohio's laws and just learn a little bit more about the facts. But again, if the tenant legally can remove the guest, then in my opinion, and I can't think of a reason why you would need the owners involved.
Great question and great clarification. I know I talked a little bit about surveillance, but I do want to hand it over to you, Adam. Can you talk a little bit about how surveillance has helped you in cases?
So I'll be honest, I've actually never had clients who had the forethought and the insight to have really good cameras or let alone use the footage. But I mean, in kind of doing some research and reading about things, certainly imagine almost every state before you evict someone, you've got to provide them with a 3 or a 5 day notice. Plenty of people say, oh, I never received that. Well, even though I tell my clients, like, take a picture of you posting it on the premises, you've got video of you or your agent, delivering that notice and it's there. That's going to be great. Further, maybe the tenant comes out and you see them on camera, rip that notice up. People do crazy stuff, and especially when they kind of forget about cameras and when they're acting emotional. So you never know what you might catch them doing. Further, tenants sometimes say, well, the landlord threatened me or I didn't feel safe or physically assaulted me or something. Well, if you got that camera footage, that would certainly go a long way to proving or disproving that claim. Somebody claims that, hey, I rented this property from Joe Schmo and I thought he was the property manager and I have no reason to think it was fake. Well, you pull the camera access and it turns out, they actually did essentially like a breaking and entering in the middle of the night to get access. And you pull that and, show the court, no, they snuck in literally in the middle of the night. So at the end of the day, verbal testimony, memories are imperfect. People are not always great witnesses. Documents can be manipulated. Sometimes they don't tell the whole story. Personally, I think a video does a great job of, better than eyewitness testimony. Again, memories fade, people get things wrong. Documents, who knows how a judge might read those, but when you're literally seeing something happen as it was recorded, it's going to be very powerful, especially in contested situations where the tenant's or squatter is really pushing back and saying, no, this was wrong and this shouldn't have happened. That video footage could absolutely become very, very helpful.
Yes. Yeah. It's very hard to dispute a verified video. Another question, any recommendations on how we should update our lease agreements or property access policies to reinforce protections against squatting?
Again, I just think you want to make sure you have really tight language on assignments, subleasing, guest policies, who is the actual tenant. If it's parent with a child, 2 parents and a child, get the children on there, make it very clear. These are the tenants. My concern is more stuff you can't get in the lease necessarily. It's friends of the tenant, family of the tenant, unscrupulous family members of the owner who are going to come in and say, well, I've been living here and I'm entitled to stay. And I just don't know that you can really structure your lease to forecast all the crazy things people are going to do to try and stay in a property and claim that they live there validly. So I really think, sorry to repeat myself, but I really think the assignment, sublease, and guest policies and who is the actual tenant, that's going to be the best thing to focus on with your lease.
Yes. And we've got another question. We're nearing the end. So if you have any final questions, go ahead and throw them into the Q&A or into the chat. We'll make sure to cover them. But nearing the end here. So if a housing authority refuses to cooperate with a squatter removal based on policy objections, what recourse does a property owner or manager have?
So, I take that one to mean, obviously in doing my research, a lot of different advocacy groups and even housing associations, they do disfavor these laws for different reasons. And I get why they do. But truly, once that law is enacted, as I understand it, I'm extremely confident in this. There's nothing anybody can do. You submit that affidavit as the owner, you show proof of ownership, that person's going to get removed. And again, it's just, the risk that if you do it improperly, you're going to probably face a lawsuit, but there's no third party that could intervene that I'm aware of.
All very, very good information. Great stuff to know, especially if you're dealing with squatters, trespassing, homeless, which has taken such an uptick nationwide. So, Adam, any final thoughts, anything to share that you would like that we haven't covered quite yet?
Not that I can think of, just this is a new and emerging area of the law. The case law is going to have a lot to say in how these things get enforced. For the most part, the laws are fairly straightforward, which is nice and fairly easy. But again, it's going to be a fairly rare, at least in my, Jacksonville is a fairly big city, but it's not Chicago or San Francisco, New York. But I think these claims are going to be unique, and it's not, I don't think, even a big property manager or property owner might only see one or two of these at most a year, and probably not even that. But it's just a good tool to have in your handbag and know when you can invoke it. Some tenants who are very brazen, like the one I had to deal with earlier this year under Florida's expedited squatting statute, they kind of thought, hey, I know the system can be gamed. I've seen people do it. And then had to explain to them, well, no, there's a new law in place and you're not going to be able to just drag this out. That was a good and powerful tool. And it was good that we had that handy, because even my client didn't know about it. And she had contacted me to just do a standard eviction. And she had already said, look, this guy told me he's going to make it a pain in the butt on me and drag it out. So it was very refreshing for her to realize she didn't have to spend a ton of money with me to draft and file a complaint and argue all that. And, we could just submit the affidavit to the sheriff's office.
There are so many scenarios. There really are. Well, thank you so much, Adam. We really appreciate your insight, your expertise, and your knowledge on that. We covered so much, and we're super appreciative of that. Super helpful. And thank you to everyone that joined. But real quick, I'm really excited about this one. Our next webinar is going to be Pause and Policy, Keeping Pets and People Safe in the Multifamily Communities. We've got Amanda Podlucky, also from Cobb Gonzalez, as well as Victoria Cohort, who is with Pet Screening. So they'll be joining me on July 10th. So go ahead and register. The link is in the chat. And then we have up on the screen both my email address as well as Adam's. Very grateful that you're open to people reaching out to you if they have any additional questions.
Absolutely.
And write that down. So you have our contact information. I'd love to chat with any of you guys that have a need for cameras, surveillance, remote guarding. And then again, Adam's email is there if you have any additional questions. So again, lastly, thank you so much, Adam. We're very grateful to have you on this webinar. Thank you for your time. Sure. And yes, join us for the next webinar, guys. There will be a recording that will be sent out, Megan. So be on the lookout for that. We'll get it sent out as soon as we have it.
All right. Thank you, guys. Everybody have a great day.
Thank you.